चलिए भाई, अगर कल ये आ गया तो कुछ लिख के आ जाना। द केस ऑफ लक्ष्मण शुक्ला वर्सेस गौरी दत्त इज अ सिग्निफिकेंट जजमेंट इन इंडियन कॉन्ट्रैक्ट लॉ, particularly concerning the validity of agreements under the Indian Contract Act 1872। ठीक है। फैक्ट्स ऑफ द केसेस में क्या लिखा है कि इन दिस केस लक्ष्मण शुक्ला प्लेंटिफ एंटर्ड इनटू एन एग्रीमेंट विद गौरी दत्त डिफेंडेंट for a transaction that was later found to be legally unenforceable. The dispute arose when one party failed to fulfill their obligation, leading to a lawsuit for enforcement. Legal issue. The key issue before the court was whether the agreement between the parties constituted a legally binding contract and whether it fulfilled the essential elements of a valid contract, such as lawful consideration and free consent. Judgment. The court ruled that an agreement that lacks essential element of a valid contract, especially if it is opposed to public policy or lacks lawful consideration, cannot be enforced. The judgment reinforced the principle that for a contract to be legally enforceable, it must meet the condition laid down in Section 10 of the Indian Contract Act 1872. Significance. The case is often cited in matters related to contract validity, emphasizing that agreements without lawful consideration or made under coercion, fraud, or misrepresentation are void and unenforceable. Implied offer, meaning and explanation. An implied offer is one that is not expressly stated in words but is inferred from the conduct of the parties or the circumstances of the case. In such cases, the offerer does not explicitly communicate the offer, but their actions indicate an intention to make an offer. Illustration of implied offer. Boarding a bus. When a passenger boards a public transport bus, there is no explicit verbal or written contract between the passenger and the bus company. However, by offering the service and allowing passenger to board, the transport company makes an implied offer that the passenger accept by sitting in the bus and paying the fare. Taking goods from a self-service store. In a supermarket, when a customer picks up an item and takes it to the billing counter, they are accepting an implied offer from the store to sell the product at the display price. Case laws on implied offer. पहला, अपटॉन अपटॉन रूरल डिस्ट्रिक्ट काउंसिल वर्सेस पोवेल 1942. Facts. A person called the fire brigade believing that it was a free service. However, it was later found that the fire service was chargeable for non-residents. Held. The court ruled that by calling the fire brigade, the person had made an implied request for the service, which constitute an implied contract to pay for it. एक और केस आ रहा है, कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कंपनी 1893. Facts. The company advertised that if anyone used their smoke ball as directed and still got influenza, they would be entitled to pound 100. Mrs. Carlyle used the product and fell ill, but the company refused to pay. Held. The court ruled that the advertisement was an implied unilateral offer which was accepted by Mrs. Carlyle when she followed the given condition. Conclusion. An implied offer arises through conduct, circumstances, or established practices rather than explicit communication. The courts recognize such offers when the intention to contract can be reasonably inferred from the party's action. फिर है, display of goods with price in a self-service store is not a proposal. Explanation. In contract law, the display of goods in a self-service store with a price tag does not constitute a proposal offer but rather an invitation to offer. This principle is based on the legal distinctions between an offer and an invitation to treat. Legal distinction. पहला, invitation to offer, invitation to treat. An invitation to offer is merely an invitation for customers to make an offer. The store does not commit to sell, does not commit to selling the product simply by displaying it. Instead, the customer makes an offer to buy when they take the item to the billing counter. Offer and acceptance. The customer's act of presenting the item at the billing counter constitutes an offer to buy the product at the stated price. The store then the store then has the right to either accept or reject the offer before finalizing the sale. Case law. Pharmaceutical Society of Great Britain versus Boots Cash Chemist 1953. Facts. Boots, a self-service pharmacy, displayed medicines on shelves. A customer picked up medicines and took them to the billing counter. The issue was whether the display of medicines was an offer or merely an invitation to offer. Held. The court ruled that the display of a goods on shelves was not an offer but an invitation to offer. The actual offer was made by the customer at the billing counter, and the store had the right to accept or reject the purchase before completing the transaction. Illustration. If a store displays a laptop with a price tag of rupees 50,000, it does not mean the store is legally bound to sell it at that price. A customer who picks up the laptop and takes it to the counter makes an offer to buy. The store may accept the offer by processing the payment or reject it. If, for example, the prices was incorrect or the stock is unavailable. Conclusion. The display of goods in a self-service store is not a proposal but an invitation to offer. This ensures that the seller retains the discretion to accept or reject an offer before finalizing the sale. Section 29 of the Indian Contract Act 1872. Agreements void for uncertainty. Text of Section 29. Agreements, the meaning of which is not certain or capable of being made certain, are void. Explanation. Section 29 states that an agreement must be clear and definite in its terms, otherwise it will be considered void due to uncertainty. A contract must be precious enough so that both parties understand their obligation and rights. If the terms are vague, ambiguous, or incapable of being made certain, the contract is unenforceable. Key element of section 29. पहला और दूसरा. पहला, uncertainty in terms. If an agreement is too vague or lacks essential details, it cannot be enforced. Second, capable of being made certain. If the terms are initially uncertain but can be clarified through reasonable interpretation or external evidence, the contract may still be valid. Illustration of section 29. Valid agreement. A agrees to sell his car to B for rupees 5 lakh. Here our terms are clear, so the contract is valid. Void agreement. A agrees to sell some quantity of rice to B without specifying the amount or price. Since the quantity is uncertain and cannot be determined, the agreement is void. Can be made certain. A agrees to sell a reasonable quantity of wheat to B at a prevailing market price. If reasonable quantity can be determined based on trade customs, the contract may still be valid. Case laws on section 29. Guthing versus Land 1831. Facts. The buyer agreed to pay an extra sum if the horse was lucky. Held. The contract was void because lucky was uncertain and could not be made certain. Scammell versus Austin 1941. Facts. A contract stated that a vehicle would be purchased on hire purchase terms, but the specific terms were not mentioned. Held. Since the terms were uncertain and no standard practice existed to clarify them, the contract was void. Conclusion. For the contract to be enforceable under Indian law, its term must be clear and definite. If the agreement is vague and incapable of being clarified, it will be void for uncertainty under Section 29 of the Indian Contract Act 1872. Void agreements definition and explanation. Definition: a void agreement is an agreement that is not enforceable by law and has no legal effect from the beginning. Void ab initio. Such an agreement never becomes a valid contract because it lacks essential legal requirements. Legal basis. According to Section 2G of the Indian Contract Act 1872, an agreement not enforceable by law is said to be void. Example of void agreements. Pehla, agreements with unlawful consideration. Section 23. If an agreement involves illegal activities, example smuggling or gambling, it is void. Example A agrees to pay B rupees 50,000 for smuggling goods. This agreement is void. Second, agreements made by minors or persons of unsound mind. Section 11. A contract made by a person who is legally incompetent. Example, minor or an insane person is void. Example, a 16-year-old signs a contract to sell his land. This agreement is void. Third, agreement without certainty. Section 29. If the terms of the agreement are vague and cannot be made certain, the agreement is void. Example, A agrees to sell some quantity of rice to B. Since the quantity is not defined, the agreement is void. Fourth, agreement in restraint of trade. Section 27. An agreement that completely restricts a person's right to trade or business is void. Example, a company forces an employee never to work for any competitor in his lifetime. This agreement is void. Agreement in restraint of marriage. Section 26. Any agreement that prevents a person from marrying is void except in the case of minors. Example, A promise B rupees 1 lakh if B never gets married. This agreement is void. Difference between void and voidable agreements. Void agreements and voidable agreements. Void agreements not enforceable from the beginning. Voidable agreements valid until one party chooses to void it. Void agreement. No legal rights arise from it. Voidable agreement rights exist until the agreement is cancelled. Void agreement. Example, agreements with illegal objects, restraint of trade, etc. Voidable agreement. Example, contracts made under coercion, fraud, and due influence, etc. Conclusion: a void agreement has no legal validity and cannot be enforced in a court of law. It differs from a voidable contract which remains valid until one party decides to cancel it. Doctrine of frustration. Section 56 of the Indian Contract Act 1872. Meaning, the doctrine of frustration appeals when an unforeseen event makes it impossible to perform a contract or changes the very purpose of the contract, making it void under Section 56 of the Indian Contract Act 1872. Legal provision. Section 56. A contract to do an act which, after the contract is made, becomes impossible or by reason of some event becomes unlawful shall be void. Key elements of frustration 1, 2, 3, 4. पहला है valid contract. A legally enforceable contract must exist. Second, unforeseen event. The frustrating event must be unexpected and beyond the control of both parties. Third, impossibility of performance. The event must make contract performance physically or legally impossible. Fourth, no fault of either party. The frustration should not result from the default of either party. Types of frustration. First, second, third. Pehla, physical impossibility. Example, a contract to build a bridge but an earthquake destroys the land. The contract is frustrated. Second, legal impossibility. Example, A contracts to supply goods to B but a new law bans those goods. The contract becomes void. Third, frustration of purpose. Example in Karel versus Henry 1903, a person rented a room to watch the king's coronation. When the coronation was cancelled, the contract's purpose was frustrated, making it void. इंपॉर्टेंट केस लॉस पहला है सत्य भरता घोष वर्सेस मुगनेर राम बेंगौर 1954. इसके फैक्ट्स क्या थे? आ बिल्डर अग्रीड टू डेवलप लैंड बट गवर्नमेंट ऑर्डर्स स्टॉप्ड कंस्ट्रक्शन. हेल्ड द सुप्रीम कोर्ट रूल्ड दैट फ्रस्ट्रेशन डिपेंड्स ऑन वेदर द कॉन्ट्रैक्ट्स फंडामेंटल पर्पस इज डिस्ट्रॉयड. सेकेंड, टेलर वर्सेस Caldwell 1863. Facts: a music hall was rented for a concert but it burned down before the event. Held, the contract was frustrated because performance became impossible. Effects of frustration: first, second, third. Pehla, contract becomes void. The frustrated contract automatically ends. Second, no liability for damages. Neither party is liable for non-performance due to frustration. Third, restitution if applicable. Under section 65, any benefit received must be returned if possible. Conclusion: the doctrine of frustration prevents unfair enforcement of contracts when performance becomes impossible due to uncontrollable events. It ensures fairness by discharging parties from obligation when unforeseen circumstances alter the contract's foundation. आगे हम बात करेंगे क्वांटम मैरिट. क्वांटम मैरिट मीनिंग एंड एक्सप्लेनेशन. Definition: the term quantum merit is a Latin phrase meaning as much as one deserves. It refers to a legal principle where a person is entitled to receive reasonable compensation for services rendered or work done when a contract is partially performed or unenforced. Legal basis: under section 70 of the Indian Contract Act 1872, if a person lawfully provides services or goods to another without any gratuitous intent, they are entitled to a reasonable compensation. When does quantum merit apply? First, when a contract becomes void. If a valid contract exists but later becomes void, the party that has already performed work can claim reasonable compensation. Example: A agrees to build a house for B. After partial construction, the contract becomes void due to new regulations. A can claim payment for the work already done. Second, when a contract is discharged by breach. If one party breaches the contract, the other party can claim payment for the work already performed. Example: A agrees to paint B's house for rupees 10,000. After half the work is done, B cancels the contract. A can claim compensation for the work completed. Third, when a contract is found to be unenforceable. If a contract is unenforceable due to technical reasons but work has been done, the party can claim for fair compensation. Fourth, when work is done without the formal contract. If a person voluntarily provides services expecting payment, they can claim compensation. Example: a tailor stitches a suit for B on B's request, but there is no written contract. B must pay a reasonable price for the suit. Important case laws. पहला, Craven Ellis versus Canons Limited 1936. Facts: a managing director worked for a company but was later found not to have been properly appointed. Held, since he provided services in good faith, he can entitled to reasonable compensation. Conclusion: the principle of quantum merit ensures fairness by allowing a party to recover compensation for work done or services provided, even if a contract is incomplete, void, or unenforceable. It prevents unjust enrichment of the other party. Thank you.